The principal legal advisor to government, the Attorney General William Byaruhanga, in his submissions told the court that the pleadings were by law closed yesterday, 8th February 2021, and at the moment, all parties had finished putting in their responses and submissions.
First of all, the court, my lord, did recognize, as you were saying, and part of the exchanges were, just to quote a few, that the pleadings, the court said the pleadings were closed by law yesterday. This is a presidential election petition. From the time a respondent files his, a petitioner files his petition and a respondent files his response, the pleadings are closed. The court is required to start hearing this matter 5 days from that time. Now you bring in a petition which we haven't seen. That's what the court was saying then. And nobody has seen. What do we do? Are you asking us to amend the rules and so on and so forth? And the argument by the other counsel was that the ones that you are hearing, I think now, somewhat similar, that these matters are so important, you need to allow us to bring everything to the court. Now, basically, my lords, that was the background, the genesis of this issue about the dispute about time frames.
Arttoney General also cited the 2016 Amama Mbaba's presidential election petition, saying that the required time to file and deliver any verdict in any petition was raised by the Supreme Court to its recommendations.
The petition has come to this Honorable Court under sections 98 and 100 of the Civil Procedure Act that provide as follows. And by the way, while I was still discussing the election petition number 1 of 2016, the recommendations by the Supreme Court to the Attorney General were taking into consideration the fact that the petitioners then were complaining about the lack of sufficient time. The recommendations which were enacted recently, the Attorney General followed the recommendation of the Supreme Court and went ahead to ensure that these recommendations were abided, and these recommendations resulted into the extensions of time. For example, the day of holding a new election if the current one is annulled, the time of presentation of your petition. Of course, sadly, the only thing that was not increased was the time for the reply by the respondent.
On this, the petitioner's time was extended from 10 days to 15 days. Byaruhanga then prayed to court to dismiss the application, saying it lacks merits on all grounds for court to grant it.
Well, I submit that the third respondent will suffer prejudice if this Honorable Court allows the amendments, because the proposed amendments are intended, in our opinion, to defeat the respondent's answers to the petition as they attempt to respond to the deficiencies raised in the respondent's answer. You see, in our view, it is disingenuous for the petitioner to now come to court seeking your indulgence to amend the petition when, as I've already said, it had more time than the respondent, who has since adhered to the strict timeline of filing the respondent's answer within 3 days from service. We therefore pray, my lords, that this court finds that there are no sufficient grounds for amendment of the petition, and the applicants have not satisfied the criteria for the grant of leave by court to amend the petition.
According to the presidential election petition rules, there is time to limit the filed petition, and this means that for court to allow the amendment, it will have violated the civil procedures rules governing the Honorable Court.
Let us recall, my lords, that under Article 1043 of the Constitution as amended, it is mandatory for the determination of this matter, together with its findings and reasons, to be in 45 days. It is mandatory. The Supreme Court shall inquire into, and that's section 59.3, and determine the petition expeditiously and shall declare its findings not later than 45 days from the date the petition is filed.
The petitioner, Robert Chagulani, through his lawyers, had asked the court to amend his earlier petition, saying that he didn't have enough time to meet and consult his legal team as his home was allegedly under siege. Robert Onyango, UBC News, Kampala.